So not only do we think that Donald Trump is making himself a witness in the criminal case against James Comey based on all of his posts, but it seems that Donald Trump is going to be massively contributing to the defense in favor of Comey based on what Donald Trump's posting. And, ultimately, will this just completely backfire in Donald Trump's face, where Trump, who is the driving force behind this against Comey, could get hit with contempt sanctions down the road because his behavior right now is consistent with what we've seen judges across the country, Democrats and Republican judges, talking about in terms of contemptible behavior by Trump proxies in these various cases. I mean, we just got a order from Judge Lamberth, a Reagan appointee, in Washington, D.C., in a case involving Kari Lake. And the judge said, again, look, had the issue of contempt been before me based on the behavior of these Trump officials, I would have found them in contempt. Hint, hint, hint. And that was a Republican Reagan appointed judge. Now, Donald Trump's been posting things that don't just cross the line in a case like this. And I'm not just talking about his social media, posts. He's been sending emails to his supporters fundraising. So not just crossing the line, but going so far out of bounds that this stuff is going to appear, I think even fairly soon, in Comey's vindictive prosecution motions and hearings regarding vindictive prosecution, to the extent Comey pursues that early as threshold issues for seeking a dismissal. I mean, this was Donald Trump's email to his supporters yesterday, 12:31 p.m. The subject line is "Justice in America." The email comes from I am Donald J. Trump, and it's a fundraising email. And I want to make an important point about fundraising, because in the Supreme Court's absolute immunity decision and in the district court cases that have been cited in the ultimate decision for the Supreme Court to find absolute immunity, some of the findings of conduct that goes outside the outer bounds of executive authority to which absolute immunity would attach is fundraising for political campaigns and the like. So this is a fundraising email. So all of my analysis, even the horrible Supreme Court's rulings, is that fundraising outside the outer bounds of what would we consider presidential absolute immunity authority, even though I don't think that should have existed in the first place. That's what our right-wing Supreme Court ruled. So here's Trump's post, "Justice in America." Then it goes, "One of the worst human beings this country has ever been exposed to is James Comey, the former corrupt head of the FBI, who was indicted on 2 felonies. He has been so bad for our country for so long and is now beginning to be held responsible for his crimes against our nation. But almost immediately, like clockwork, the radical left began rallying behind this dirty cop while attacking yours truly. So here's how we're going to respond. I'm calling on 1 million of my top supporters to rise up and declare, I stand with President Trump over the corrupt swamp." You click the link and it brings you to a fundraising website to give Donald Trump money for his joint fundraising committee and other committees as well. So notice Donald Trump doesn't say alleged crimes. He says this is the worst human being, a dirty cop. He's being held responsible for his crimes. He knows very clearly, he speaks to Pam Bondi, "Pam, I need you to do this for me," that this is a violation of every rule about publicity when it comes to cases like this. So I want to bring in Harry Litman from the Talking Feds YouTube channel, the Talking Feds podcast, because clearly he's making himself a witness. Like, that's a given. But this as an exhibit right here, brought by James Comey in any normal time, in my view, would clearly meet the criteria for a vindictive prosecution defense. But also, this behavior is contemptible. We know one of the things I think James Comey is going to seek with this as an exhibit is a restatement of the local rules and what the rules are, that you can't engage in this behavior. You know, Trump's just going to ignore it anyway, and he's going to continue this stuff. So, Harry, what do you make of this? Because this document right here, to me, already reflects all of the criteria to meet vindictive prosecution.
Well, so a couple things. First, yeah, man, is he asking for it? The only reason the hammer on something like this won't come down immediately is because I think first Judge Nachmanoff has to go through the move of a very stern lecture, then issuing an order. And yet, I mean, it's typically, as you say, already a violation. Look, just imagine, what are we worried about here? A number of things, but the jury pool, right? Imagine if you played this video for a jury, and then this is the president of the United States saying, and not simply saying he did the crime, that'd be very bad, but basically saying he's a scumbag and punish him for that reason, which is a completely impermissible and prejudicial thing to even think about. So he is, trying to do exactly what the rules prohibit and inflame a jury. He's president. We've been here before, so Nachmanoff, you can expect to first lower the boom and maybe to Bondi or White House counsel or whatever. But yeah, he's getting in real trouble. He's going to get real crosswise and fast with the judge. Now then, second, do we have a selective prosecution? I actually write about that in my Substack today. First, I think it would be selective and not vindictive. They're often lumped together, but vindictive is typically for the exercise of your rights, like plea bargains. Selective requires that you've been selected out from among many people who wouldn't be prosecuted, and that's sure right. This sort of picayune little statement that had nothing to do with anything in Congress would not serve as the basis, and for impermissible reasons. The most common ones being the protected characteristics in the Constitution, race, religion, and the like. But I think pretty clearly when you do it for reprisal and in response to basically what I think has to be First Amendment rights, that's going to fly as well. Now, there'll be different arguments, and and all your listeners know, very, very hard kind of motion to raise and win, and they'll say different kind of things like, well, nobody who has similar situated hasn't been prosecuted because he's the head of the FBI, and that's special, for example, because we have thousands and thousands of situations like this where really nothing has happened. Or they'll say something, I think, will they be so brazen, but maybe, as to say, oh no, this is all just factual. Yeah, we know that the president had some hot rhetoric, but that had nothing to do with the decision here. And I think in that instance, Nachmanoff makes a finding of fact, and it's overwhelming. Oh, I don't think so. Oh, yes, they did. So he is absolutely every day giving more fodder for what's already the strongest selective prosecution case I've ever seen. And then in addition, he's acting, and he knows it, he's been chastised again and again, dirtying up a defendant who's already been indicted is strictly improper. But of course, so is indicting a defendant who you don't have the evidence for. All of this, everything he's doing with respect to Comey, he's a walking constitutional wrecking ball. He knows it, but the final point I want to make is you're right about the immunity decision, but for the reasons you say, there's lots of things. Nobody has to accuse Trump of a crime in order to wrap his knuckles, shut him down, and go very hard. Among other things, I think it's interesting because the case is so weak in so many ways. But if he's really incorrigible, something in Nachmanoff's quiver is to say, you pull this crap one more time, I'm dismissing the case. That's something they can do. And this is a general illustration, Ben. We've seen, district court judges really rise to the occasion only in half, 2/3 of the case to have the big boot of the Court of Appeals, or more likely the Supreme Court, come down on them. But the management of their court and a trial and indictment where they U.S. government is going around completely tarring the defendant. That really is something that higher courts understand. You gotta let a district court manage things there. It would be really intrusive to try to clip Nachmanoff's wings here. If they can do anything, they can control their courtroom, and he'll be smart enough. He won't, come out of the box with contempt. He'll, give a warning and then another warning and the like. So long way of saying you bet to your question of, is he really leading with his chin, both endangering the prosecution, making it more likely that he will testify, and potentially even inviting sanctions against him personally? The answer's yes, yes, and yes.
The MeidasTouch Network got the first exclusive with Andy McCabe. I'm not sure if you heard it, where he spent 45 minutes speaking with Allison Gill. They do that show together. Mm-hmm. And so, of course, we wanted to put that first on the MeidasTouch Network, where, he said, look, if the Trump people think that I'm the witness who's going to confirm that I was authorized by James Comey to leak, they're mistaken. I don't need to be authorized by Comey. I did it, but I have
the authority myself.
I authorized it myself. So, so that leads us to believe that it was the DOJ official, perhaps, who is the person 3 in the indictment, Richmond. But even there, what we know already is that Eric Siebert had, I think, spoken with Richmond and interviewed him to see if he'd be a witness that would be helpful, because McCabe's not going to be helpful to the case. After speaking with Richmond, you had the top prosecutors in Virginia before Trump pushed them all out. There's not a case here. So we haven't heard publicly yet from Richmond, but that's the last piece of this. So unless there's a secret magical person who we're unaware of, or somehow they think that Ted Cruz is going to testify on double hearsay, there is no there. And so, as I'll pass this to you to give your final reflections, but I'll talk about a learning experience that I had as a young lawyer, because very early on in my career, I didn't fully appreciate, I think, the power of my pen as a lawyer and what it meant when you filed a lawsuit, because I was immature, I think, in the sense that it was a maturing experience. That when I would file a high-profile case and my name would be on it, very earlier in my career, there was a seductive element, if you will, perhaps not the right word, but that people cared. And the story got out there and people would write about it, and you felt important, and you would get a great headline, and it felt empowering to you that existed. But what you learned over in the career as a second-year lawyer, not a first-year lawyer, then as a third-year lawyer and a fourth-year lawyer, is that the headline lasts a day or two and you may get great press. But what's important is you prove your case, most importantly, whether that's on the defense or on the offense as a plaintiff or a prosecutor. So Trump and all of these things, and this is how he litigates, Trump was always someone who would love to grab the headline, post the number, 100 billion, 50 billion, whatever it is, and that works. You're going to get the headline. But now you got to prove the case. Now you're in the world of facts and evidence. And it don't seem like they got it. Let me give you the last word.
Yeah, our last words. I got a few things to say. First, your point is really well taken on reputation, but that it's a long game, not a short game. And there are people who are flashy and quotable who wind up not having it, and their reputation goes where you might expect, and pretty quickly. Something about Richmond. So it does seem it's so perplexing. One of the bases they're going to be raising, if it ever gets to this point, is this question by Cruz is so confusing. Nobody could even know what's true or what's not. But it does appear, it certainly talks about McCabe, but it does appear pretty clear now from reporting that number 3 is Richmond. And there's a separate point here. I did a Substack yesterday, Ben. 10 flaws, fundamental flaws with the Comey prosecution. 10 sounds like a nice round number. Maybe you think I'm making a few up. I am not. There are 10 fundamental flaws, and one concerns Richmond. The indictment, the incredibly poorly drafted indictment, says, nothing about the words Comey says, but says at one point that he made an instruction to someone in the FBI. If they're not in the FBI, if they instructed you or me, there is no case. You got to throw it out. Richmond. When he's a longtime friend and a former colleague in the SDNY with Comey. Comey did rely on him, and when this got really dicey, remember Trump saying stuff that could, and oh lordy, he better hope doesn't a tape. In fact, he had very good notes, and they were going to show that Trump said exactly what Comey said he said, and he knew for his own protection he better keep them. And then a time came where he wanted to leak them. We'll put that to the side, although I will just say, leaking is so endemic in Washington, and it really is sort of gambling in the casino. But back to Richmond, he had brought him in. He's a teacher at Columbia. Comey brought him in just so they'd be able to talk together as a so-called special government employee. You can do that. But even that, you're not paid, you're not whatever. So it already raises the question, is he, quote, in the FBI as he needs to be? But his appointment ran its course in like 2016, and as a matter of just bureaucratic process, they sent him the new one to sign and stay on. It looks as if he never signed it. So he's there, but it looks as if he never signed it. So it looks, in other words, that it may well be that come when this happened, he in fact was not even, quote unquote, in the FBI. One of 6 different ways the case could go south and fast. And I just wanted to make sure your listeners had a sense of it.
We'll keep everybody posted every step of the way here. Again, not just a weak case, but it just seems there's no there at all. And what I'm really interested in, Harry, is what the hell did Lindsay Halligan, who's never appeared before a grand jury, tell that grand jury? The defense is going to get their hands on that grand jury transcript. Well, did she have there's an obligation if you're a prosecutor, which she never was, as you know, Harry, more than anybody, if there's exculpatory evidence, you can't hide that in front of the grand jury. So she would have had to have told the grand jury, hey, by the way, we know that Andy McCabe actually said that he was never authorized, and we know that Richmond has. You can't hide that. So if you were to give the grand jury a one-sided story only, based on Ted Cruz hearsay and an FBI agent just talking about that, I can see how they would indict, because you haven't given the other side of the story. If you know it exists, you can't bury it. And my gut tells me that she went into the grand jury, did not provide the facts about McCabe and Richmond, that will be obvious, that there'll be an evidentiary hearing, which whatever FBI officer they called is going to go up there and say, did you know about this? Were you given this in your file? Would that have changed your opinion? And the FBI, blah, 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 no one told me about that, blah, blah, blah. That's what we're going to see happen.
I really think so, man. And remember, she was so between a rock and a hard place. She doesn't want to lose her license, but she knows she's got to go do Trump's bidding, come back with the scalp, with the indictment. Did she lean? I mean, look, everybody who's listening, imagine that in 5 minutes you have to go into a grand jury and ask 23 people to do an indictment. That really is who she is. She never even been in a prosecutor's office before, a few days before that. And the pressure and high profile of this was pretty big. So there is every reason to believe, as Ben says, that when that grand jury transcript comes out, she's going to look like a fool. In the last few days, she stood on the wrong side of the, can't blame her in one sense. She has no friggin' idea. She's, doesn't even play a prosecutor on TV. So wow, could that be ugly? And I think in general, she is really the person most likely to join the club. Everything Trump touches dies. She put it on the line for him. And I think she's going to very possibly be just humiliated.
Oh, yeah. That federal judge is going to be able to smoke that out right away. And just everybody come back and watch this. I guarantee you, evidentiary hearing, FBI agent, were you told this? So you went into the grand jury, I think it'll happen fairly quickly. In court time, so in the next 90 days or so, which is
Eastern
maybe
District, rocket docket, arraignment on the, on the 9th, and he'll set a schedule. It'll be basically up to Comey. I think Comey makes it seem like maybe he wants to trial, maximum vindication. Fitzgerald, an awesome attorney, I think has to be thinking, don't be so cute, Jim. We want to get you off first and foremost. There's a lot of strings we can pull. We should pull them all. We'll see how that plays out.
Everybody hit subscribe. Let's get to 6 million subscribers. But most importantly, subscribe to Harry Litman's YouTube channel, Talking Feds. Subscribe to Harry Litman's Substack, Talking Feds. And guess what his podcast is called? Talking Feds. Search it, subscribe. Thanks, everybody, for watching. We appreciate you.
Thank you, Ben. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.